The freedom of movement for workers is a policy chapter of the acquis communautaire of the European Union. It is part of the free movement of persons and one of the four economic freedoms: free movement of goods, services, labor and capital. Article 45 TFEU states that the right to free movement has both horizontal and vertical direct effect, such that a private citizen can invoke the right, without more, in an ordinary court, against other persons both governmental and non-governmental. History. The Treaty of Paris establishing the European Coal and Steel Community established a right to free movement for workers in these industries, and the Treaty of Rome provided a right for the free movement of workers within the European Economic Community. The Directive 2004/38/EC on the right to move and reside freely assembles the different aspects of the right of movement in one document, replacing inter alia the Directive 1968/360/EEC. It also clarifies procedural issues, and it strengthens the rights of family members of European citizens using the freedom of movement. According to the official site of the European Parliament, the explanation of the freedom of workers goes as follows: freedom of movement and residence for persons in the EU is the cornerstone of Union citizenship, which was established by the Treaty of Maastricht in 1992. Its practical implementation in EU law, however, has not been straightforward. It first involved the gradual phasing out of internal borders under the Schengen agreements, initially in just a handful of member states. Today, the provisions governing the free movement of persons are laid down in Directive 2004/38/EC on the right of EU citizens and the family members to move and reside freely within the territory of the member states. However, the implementation of this directive continues to face many obstacles. Definition of worker. The meaning of worker is a matter of European Union law. The essential feature of an employment relationship, however, is that for a certain period of time a person performs services for and under the direction of another person in return for which he receives remuneration. Purpose. Under the ECJ case law, the rights of free movement of workers applies regardless of the worker's purpose in taking up employment abroad, so long as the work is not solely provided as a means of rehabilitation or reintegration of the workers concerned into society. Time commitment. The right of free movement applies to both part-time and full-time work, so long as the work is effective and genuine and not of such small scale, or irregular nature, a limited duration to be purely marginal and ancillary. Remuneration. A wage is a necessary precondition for activity to constitute work, but the amount is not important. The right to free movement applies whether or not the worker required additional financial assistance from the member state into which he moves. Remuneration may be indirect, quid pro quo, rather than strict consideration for work. Direction of another. Where a person is self-employed, he can avail himself of the freedom to provide services and freedom of establishment. Extent of the right. The right to free movement applies where the legal relationship of employment is entered into in or shall take effect within the territory of the European Community. The precise legal scope of the right to free movement for workers has been shaped by the European Court of Justice and by directives and regulations. Underlying these developments is a tension between the image of the community worker as a mobile unit of production, contributing to the creation of a single market and to the economic prosperity of Europe, and the image of the worker as a human being, exercising a personal right to live in another state and to take up employment without discrimination, to improve the standard of living of his or her family. Discrimination and market access. Case 379 87th Schreiner v. Minister for Education ECR 3967, Cases 267 and AMP 268 91st Kecken Mithwa ECR I-1697. Case 1895 F. C. To her v. Inspecteur van der Belastingdienst Particularen Ondernemingen Buitenland ECR I-345. Public Service Exception. Case 149 79th Commission v. Belgium ECR 3881. Case 152 73rd Sotage v. Deutsche Bundespost ECR 153. Directives and Regulations. Directive 68 360th EEC. Case 48 75th Roy ECR 497. Case 118 75th Watson and Bellman ECR 1185. Case C-292 89th Santanis and ECR I-745. EU Regulation 1612 68th repealed and replaced by Regulation 492 2011. Case C-207 78th Ministère Public v. Even and ONPTS ECR 2019. Case C-267 83rd Dieter v. Land Berlin ECR 567. Case C-370 90th SAR v. Immigration Appeal Tribunal and Surinder Singh, ex-party Secretary of State for the Home Department ECR I-4265. Social Rights. Case 293 83rd Gravier v. City of Liege ECR 593. Case C-85 96th Maria Martinez Sala v. Freistaat Bayern ECR I-2691. Case C-184 99th Rudi Gretschik v. Centre Public Dried Social Detains Leuvenlander v. CR I-6193. Transitional provisions in new member states. In both the Treaty of Accession 2003 and the Treaty of Accession 2005, there is a clause about a transition period before workers from the new member states can be employed on an equal, non-discriminatory terms in the old member states. The old member states have the right to impose such transitional period for 2 years, then to decide to extend it for additional 3 years, and then, if there is serious proof that labor from new member states would be disruptive to the market in the old member states, then the period can be extended for the last time for 2 more years. According to the principle of reciprocity, new member states have the right to impose restrictions for all the countries that introduced restrictions and transitional periods to their citizens. Croatia has decided to apply this rule. Further, the citizens of the member states of the European Economic Area have the same right of freedom of movement inside the EEA. Also, the European Union and Switzerland have concluded a bilateral agreement with the same meaning. The EEA member states outside the EU and Switzerland are treated as old member states in regard to the Treaty of Accession of the new EU members, so they can impose such 2+3+2 transitional periods. Switzerland initially granted freedom of movement to EEA citizens in 2005 to 2011. It briefly reimposed restrictions in 2012-2013, but lifted them again in 2014. However, as a result of the popular initiative against mass immigration, Switzerland is scheduled to impose permanent quotas on residence work permits for citizens of all the EEA countries except Liechtenstein, starting from 2017 at the latest. Liechtenstein imposes a permanent quota for all EEA citizens. Notes Bibliography P. Craig and G. DeBurker, EU Law, Text, Cases and Materials, 3rd edition, OUP, 2003.